Hello law students. Welcome to the legal school. I am Neelam Kejriwal and in today's video we'll be breaking down the recent judgment of Supreme Court where Supreme Court stated that 3 years practice is mandatory now in order to write judicial services examination. So in today's video we'll be talking about that and how you can actually make this 3-year count and make sure that after those 3 years when you write for the examination, when you sit and write judiciary examination, you are not actually out there without any plan. You actually have some plan ready for you. Before we move ahead to that, let's go ahead and let's try to understand what this judgment is, how is it going to impact you, and what all you can do as a smart lawyer at this stage to make sure that these 3 years are counted for. These 3 years are not gone just towards your preparation for judiciary, but at the same time you have made sure that even if it doesn't work out well for me, what is there in store for me? So without further delay, let's get started. So first and foremost, and if we try to understand what actually happened in this case, what really happened in this case. So yesterday, division bench led by the Chief Justice of India B.R. Gavai gave the judgment where they stated or where they restored the fact that now in order to write the civil judge examination, 3 years of courtroom practice is something which is mandatory. So they have mandated the 3 years practice for courtroom, but at the same time they have also banned the fresh graduate from entering into the judicial services. So this is what was laid down in the judgment, that now you need the requisite experience in order to go ahead and write the examination. Freshers cannot go ahead and write the examination. But why was it required? Why really it happened? What was the background of it? So let's go a little bit on the inside and try to understand that what really happened here. So in this case, we have often seen that fresh law graduates who graduate from their law college, they are eligible to write the judiciary examination without any courtroom exposure. So this created some rift between those who were already there in the court and the fact that these fresh graduates were not well versed with the courtroom etiquettes, courtroom procedures. So in order to bridge out that gap, further, to make sure that the fresh graduates are also in whose hands, if they go and become the judge, so in their hand the life, liberty and property of certain people were there. So they are having enough training, enough exposure before they actually go ahead, sit and give the judgments. They have enough exposure to how court actually work, to the courtroom procedure. So that is why there was some dispute going on that should the 3-year practice be made mandatory. Initially in 2002 judgment, court cited upon it, court observed this, that okay, 3 years practices should be there, but court did not make it mandatory. Court never made it mandatory in 2002 judgment, but court observed that it might be required. Thereafter, the appointment of junior civil judges were governed by the state judicial service rules, which stated or which provided that in some states the 3 years requirement was there, but in most of the states fresh graduates were eligible to go ahead and actually write the judiciary examination, and after the training they were supposed to go and sit and give the judgments, and they were eligible to become the civil judges. Now the question arose with respect to Article 233, the criteria, and in this judgment, when the court was giving the judgment, court also referred to Article 233, stating that the current requirement is in sync with Article 233. Now what is there in Article 233? So Article 233 states that for somebody who is actually who has not worked at union level or at state level, then in that case the person is supposed to serve for 7 years as an advocate, to practice for 7 years as an advocate before the person is eligible to write district judge examination. Now this judgment was also appreciated as well as criticized, because at one point of time we see that this judgment is trying to bridge the gap between the real life experience that the fresh graduate requires, but at the same time it was also criticized on the fact that it is in a way creating inequality between the fresh graduate who will graduate now, so that they are not getting the chance to go and write the judiciary examination. Second most important point that for which the judgment was criticized was that Article 233 talks about the eligibility criteria to be appointed as a district judge. But when we talk about the entry level, that is the civil judge examination, Article 233 is not mentioning anything about that. So in that case, mostly it was governed by the state judicial services rules, and where all the states almost have accepted this fact that okay, as soon as the fresh graduate come out of the law college, they are eligible to write the examination. So in this case, it was also stated that this is little bit contradictory. So that is why this judgment was also criticized. If we look at what all things this judgment entails, so apart from this, the judgment is also made prospective in nature. What is this term prospective? Why the judgment is made prospective, or what does this prospective nature will make sure? So it will make sure that till date, whatever notifications are out or whatever judicial service appointment procedures are going on, this judgment, the scope of the judgment will not cover those procedures which are already running. But for future recruitment, this judgment will be there, and all the state high courts are also, or the state judicial service boards are also given this option, or are given this chance to make the rules and the procedures accordingly, so that the future recruitments are done adhering to the guidelines given in this judgment, adhering to the mandate provided in this judgment, right? So this is what the term prospective here mean, right? Now, when we talk about the observation of the court here, when we talk about the key observations, so court had made sure that there is a gap which is there between what you learn at law school and at the same time what skill set you are required when you are actually going and practicing in the court. So that beyond theory concept, the fact that you require that knowledge beyond theory is one thing that the court is trying to bridge, and which was observed by the court here. Then thereafter, the justice delivery system will also require the practical training, which a candidate will always get when the candidate is going and actually practicing in court, instead of sitting in the classroom or instead of directly going for the judicial training. Lastly, the judgment of the judges also have real world impact. So in that case, real world impact is there for the judgments that are delivered by the candidate. So they cannot go and directly give the judgment. They need to understand the nuances of the judgment, the nuances of the people who come there, right? So that is why this mandatory 3 years period is required for them to get that practical exposure. This is what was observed by the court in the current judgment. Now, when we have understood in crux that okay, this is what the judgment was, this is what the key observation of the judgment was. How is it going to impact the candidates who are going to write the examination? So first of all, in this case, those who are going to write the examination now, straight out of their college, they cannot go and write the examination. What they are supposed to do? They are supposed to go to court and practice for 3 years before they can actually go and write the judiciary examination. After that, also, one more thing that is necessary here is bar enrollment. So, state bar council enrollment is something which is important here, which has become mandatory here, because the 3-year countdown will start only when you enroll with the state bar council, get your provisional certificate to practice, and when you start practicing, that is the time when the 3 years countdown period will start, right? So that is one thing because of which the state bar council registration is important, as well as the courtroom practice is one thing which is mandatory now for those fresh graduates who are coming out of the college and are aspiring to write judiciary examination. Next is with respect to how those 3 years will be calculated. So court had also made sure, or court had also guided about the fact that how these 3 years will be calculated. So for that, somebody who is practicing in the court, for them, they need certificate of someone, or they need this certificate from someone who is already who already has 10 years of standing in the bar, along with the endorsement from the judicial officer of that respective court. So this certificate will be valid. Apart from this, court has also mentioned that if somebody is having the experience, the requisite exposure as judicial clerk, as law clerk to a judge, then that experience, that period will also be counted, will also be accounted for when we are calculating this 3-year period for writing the judiciary examination. So this is how your 3 years experience will be counted for because you have the courtroom experience here. So this is what the judgment is mentioning about your 3 years period. Now the next and the most important part here is that, okay, we understood that this is the judgment, this is how 3 years will be accounted for. But when we look at this examination, at the end of the day, this is a government examination. And we have also seen, those of you who are aspiring to become the judge in near future, or those of you who are already appearing for the examination, we have also seen this fact that this exam is something which a lot of law students write. So when we see the competition, specifically for those who come from Hindi belt, or those who go and target the examination in the Hindi speaking state, right? Because language also play a huge role in this examination. So when we talk about this, then in that case, I will always have an uncertainty that what if I'm not able to clear this examination, because once I get out of the college, earlier what used to happen, I have that luxury of time where I can actually go and write this paper and attempt. I can also give re-attempts. But in this case, first of all, when I graduate out of my college, then I have to wait for 3 years before I can go and write this examination. Then I will go and take the attempts. Now this attempt will also depend on one fact, that whether the state is releasing the judiciary vacancy or releasing the examination notification for this year or not, because the notifications are also not consistent. It is also depending on the vacancy, the need, the budget of the state, and then the notifications are released. So whether the notification is released or not, whether I am eligible at that point of time or not, so these things also come in play. Now even after everything, let's say, get smoothen out, and okay, 3 years have passed, and then I am going to write the examination, the notification is also out. But when we see the success rate for this examination, success rate is even less than 3% for those who are writing the examination, because the process is not very easy. You go and you appear for preliminary examination. Then those who are selected go from the preliminary examination process, they go and write the mains, and thereafter you go and appear for the interview, right? So seats are also limited, competition is high, success rate is less. Then in that case, what if, let's say, I have spent 3 years to become eligible to write this examination, but even after spending those 3 years, I am not able to clear it. Then in that case, what will happen to me? So in this case, those of when we talk about us, we also have time period, we also have space here, not just to make sure that okay, I'm preparing effectively for this examination, I'm using those 3 years to prepare effectively for this examination. I also have that space to make sure that I am also side by side building a plan B for me. What is this plan B for me? It will make sure that, let's say, tomorrow, for any XYZ reason, if judiciary is not working out for me, I have a secure plan B ready for me. And at the same time, while I'm waiting for this 3 years, initially when we talk about career in litigation, it does not pay really well, because we all have faced this. Even when you go for internship, even when you go and start your journey in litigation, the initial years are the years where you struggle a lot, right? We often don't see a lot of income coming in to ensure your survival, to ensure that you are sustaining on your own. So with this part B, I can also go ahead and ensure that I have a source of freelance income just by devoting 4 to 5 hours of my day. I have that much income ready for me, on that too not on a daily basis, that too maybe on a weekly basis. If I'm devoting 4 to 5 hours or maybe 6 hours of my week, I have a source of income ready for me. So in a smart lawyer here will invest not just in the preparation but also making sure that, let's say, if this plan is not working out for me, then what is there with me to make sure that I have something ready after investing those 3 years and then writing the examination, waiting for the vacancy, and after going through all those procedure, what is there ready for me, what is there that I have with me, so that after spending 26-27 years of my life, I have something ready for me. So here I am today giving you this tip that this is how you can actually go ahead with your preparation. So you have 3 years to prepare well for the examination. Target your state, that for this state I'm going to prepare for the examination. There are certain common subjects that you prepare for every state, except for certain local laws that varies according to the state. So prepare those 7-8 subjects and then eventually divide it across the period of 3 years, so it will require less time to prepare, as well as will make sure that you are actually preparing completely for these 7-8 major papers which are there that you need to prepare for every examination. Thereafter, after preparing for judiciary, ensuring that you have devoted some time during your week or during your day to prepare for judiciary along with the courtroom practice which is required, you are using your weekends, you are using your time to even make sure that you are upskilling yourself, so that upskilling yourself in different courses. There are numerous courses that are available for you through which you can upskill yourself in the contract drafting market, in the IP market, and you can actually have a plan B ready for you. And there are so many freelance options available through which you can actually make sure that while you are preparing for judiciary, you are also securing your future, and you are also making sure that there is a steady income flow to ensure your survival through these 7 years. If you want to know more about this, that how actually you can balance out your judiciary preparation along with your courtroom practice and your upskilling, I am here to announce it for you that we are hosting a webinar on this very topic, because we have received a lot of queries and then students were really confused about how actually I can go about it, that I want to prepare for judiciary, that is my dream, but at the same time I have to make sure that I'm going ahead with the mandate which is there, that I have to get the courtroom experience. But at the same time, I don't want to look after my journey after those 26-27 years and see that, okay, I don't really have anything now with me, what should I do? So this webinar is entirely about how you can actually balance out the 3 things and make sure that, okay, after spending 26-27 years of your life, you have something in place ready for you. This webinar is going to happen on 23rd of May at 8 p.m. where we'll be talking about judiciary, litigation, and how you can actually build this freelance option. And we'll be trying to balance out, we'll be here giving you tips, and we'll try to balance out your preparation along with upskilling and the freelance option. So if you want to join us for this webinar, make sure that you are clicking on the link in the description box and registering yourself for the webinar, and you'll get the link to join the webinar in your email ID and your WhatsApp number as well. And see you all in the next video. If you like the information that is there in the